Okay. I I thought I had Mr. Woodsmall as number 4, but you're number 4. So just wanted to get everybody identified here. Okay, we'll give everybody just another minute, make sure everyone that was going to call in. I did have someone else join by phone. Can you identify yourself?
This is Sungjun Won staff.
Okay, thank you. Think we're close to having everyone. Okay, I've had a couple more join me by phone. If you called in by phone, could you identify yourself? I still have one caller showing up as call-in user number 6 on my line. Did anyone, you may have to unmute yourself.
Can you hear me, Judge DePaul?
Yes, I can.
This is Shelley Bergman. I had to unmute in 3 places. I'm sorry.
That's all right. Thank you. I can see your name. So, but maybe one of the others is you. I'm going to give just another minute. I think there may be another commissioner or two who hasn't yet joined us. Okay, I think we can go ahead and get started with entries and so forth, and then anyone else that might be having trouble joining us. Although I did just have one last caller phone in. Join us. Can you identify yourself? You may have to unmute. Okay, they identified themselves or they dropped off. All right, then let's go ahead, and if our court reporter is ready. All right, let's go ahead then and go on the record. Good afternoon. This is case number WR-2020-0344 in the matter of Missouri American Water Company's request for authority to implement general rate increase for water and sewer service provided in Missouri service areas. My name is Nancy DePel. I'm the regulatory law judge assigned to this matter. And we've come here this afternoon for an on-the-record presentation of the stipulation and agreement that the parties have reached. We're meeting via WebEx due to the COVID-19 pandemic. We're meeting remotely. I would ask that since we are meeting remotely, that unless you're speaking, you keep yourself muted. And to aid the court reporter, especially if you're not on the video and have an identification, if you could give your name before you speak. So I'm going to begin then with entries of appearance by the attorneys. Can we start with Missouri American, please?
Thank you, Judge. This is Dean Cooper. I'm appearing on behalf of Missouri American Water Company. I'm from the law firm of Bryden, Swearingen & England, PC, P.O. Box 456, Jefferson City, Missouri 65102. Also appearing on behalf of Missouri American is Mr. Timothy Luft of Missouri American Water Company. His address would be 727 Craig Road, St. Louis, Missouri 6341.
Thank you. Commission staff.
Thank you, Judge. On behalf of the staff of the Missouri Public Service Commission, Mark Johnson. My address is 200 Madison Street, P.O. Box 360, Jefferson City, Missouri 65102.
Thank you. Office of the Public Counsel.
Good afternoon, Judge. Caleb Hall appearing on behalf of Missouri's Office of Public Counsel. Our office address is 200 Madison Street, Suite 650, Jefferson City, Missouri 65102.
Okay. Missouri Industrial Energy Consumers.
On behalf of the MIEC, Diana Plusha of the law firm Curtis, Hines, Garrett, and O'Keefe. That's 130 South Bemiston, Clayton, Missouri 63105.
Thank you. Missouri Energy Consumers Group. Mr. Woodsmall, if you're speaking, we can't hear you. We need to unmute. Okay, we'll come back to Mr. Woodsmall. I know he's there. Consumers Council of Missouri.
Good afternoon, Your Honor. This is John Kaufman on behalf of the Consumers Council of Missouri.
City of St. Joseph.
Thank you, Your Honor. Please let the record reflect the appearance of William D. Steinmeier, PC, 2031 Tower Drive, Jefferson City, Missouri 65109, appearing on behalf of the City of St. Joseph.
And City of Riverside.
Joe Bednar, law firm Spencer Fain, with representing the City of Riverside. Address for my law firm, 304 East High Street, Jefferson City, Missouri, 65101.
And the Public Water Supply District number 2 of Audrain County.
Yes, Judge, on behalf of the Public Water Supply District number 2, actually of Andrew County, I'm James Fisher of the law firm of Fisher and Doherty PC. Our address is 101 Madison Street, Suite 400, Jefferson City, Missouri, 65101. Thank you.
And Sunnydale Properties.
Your Honor, Stephanie Bell, on behalf of Sunnydale Properties with the law firm of Ellinger and Associates, and the address is 308 East High Street, Suite 300, Jefferson City, Missouri.
Triumph Foods.
Joshua Harden on behalf of Triumph Foods with law firm of Collins and Jones, PC, address 1010 West Foxwood Drive, Raymore, Missouri.
Liberty Utilities.
Diana Carter for the Empire District Electric Company, 428 East Capitol Avenue, Suite 303, Jefferson City, Missouri, 65101.
And the Municipal League of Metro St. Louis. They had previously asked to be excused, but I wasn't sure if Mr. Turner was here. Mr. Woodsmall, are you able to make your appearance now?
Can you hear me now?
Yes, we can.
Oh, I wonder what the problem was. David Woodsmall on behalf of MECG, and my mailing address is in the record already.
Thank you. All right, I believe unless I missed someone, was there anyone else that needed to make an entry? I think I got everyone. All right, great. Well, we're going to just begin with the parties sort of presenting the agreement, what it involves to the commissioners, and I'll let the commissioners ask any questions they may have as we go. So if it's okay, I'd like to start with the company, unless you all had earlier worked out something different.
That'll be fine, Judge.
All right.
Good afternoon. We're happy for this opportunity to describe the stipulation and agreement that was filed in this case on March the 5th, and to answer any questions you may have in regard to that stipulation. This stipulation agreement, of course, if approved and ordered by the commission, would represent a resolution of all issues in this case, and has been referred to by the parties along the way as a global stipulation as a result of that. The signatories to the agreement represent a fairly substantial grouping of the parties to this case, in addition to Missouri American Water Company, also the staff of the Missouri Public Service Commission, the Office of the Public Counsel, MIEC, MECG, the City of Riverside, the City of St. Joseph, the Consumers Council of Missouri, the Public Water Supply District number 2 of Andrew County, and Sunnydale Properties are all signatories. The remaining parties that are not signatories are the Empire District Electric Company, the Municipal League of Metro St. Louis, and Triumph Foods. And all three of these parties have not objected to the stipulation, nor have they requested a hearing. Thus, the stipulation by commission rule may be treated as a unanimous stipulation and agreement. The signatories have agreed to an overall annual revenue requirement of $348 million for Missouri American Water Company. That's approximately $335 million for the water side and approximately $13 million for the sewer side. This revenue requirement of $348 million is inclusive of approximately $25 million of benefits flowing to the customers from the Tax Cuts and Jobs Act of 2017, which reduced corporate tax rates from 35% to 21%, resulting in a, as you can do the math, 14% tax reduction. Since the end of the true-up period in Missouri American's last rate case, which that true-up period ended at the end of the calendar year 2017, Missouri American has made capital investments of approximately $620 million. After the impacts of the TCJA, the $348 million revenue requirement represents a net increase of $30 million, approximately $30 million, over the company's revenue requirement that was authorized in its last general rate case. Now, the question usually arises, what does this really mean for customer rates along the way? First, I'd point out that there is no change to the existing tariff groups or districts that resulted from the last Missouri American rate case. At a high level, the result of the agreed to revenue requirement and billing determinants results in the water customers in St. Louis County seeing slight reductions compared to what they are currently paying between base rates and ISRIS rates, and most water customers outside of St. Louis County seeing no change to their existing rates. The exception to that would be the city of Lawson, which will see a rate reduction as a part of the process of moving from its own rates prior to acquisition to Missouri American's rates. Sewer customers will see an increase of approximately 15%, which for individual customers, for the most part, will be about $3.50 to $5.28 per month for customers. There's a larger increase for the city of Lawson sewer rates, again, resulting from moving them from their own rates to the company's rates in this rate case. But that increase on the sewer side will be substantially offset by the reductions in the Lawson water rates I referred to previously. From there, I'd like to move on through the provisions of the stipulation agreement, and we'll do so largely that they arise. There's a provision in regard to the infrastructure system replacement surcharge. The parties have agreed that on a going forward basis, the pre-tax weighted average cost of capital for the ISRIS will be 8.71%. Parties have also agreed that all ISRIS eligible investments placed in service beginning January 1st of this year of 2021 will be eligible for the ISRIS mechanism as we move forward. The billing determinants that have been agreed to by the parties are found at attachments A for water and B for sewer to the stipulation. As I mentioned before, the benefits from the TCJA are being returned to customers in this case and result in lower rates for customers than they would otherwise see. The protected excess ADIT is going to be returned to customers using the ARAM method. The unprotected excess ADIT will be returned to customers over a 10-year period. And the stub period, that period from January of 2018 through May of 2021, will be returned to customers over 2.5 years. Accelerating this tax benefit is a key component, which allows, in particular, the water customers' rates to remain largely unchanged coming out of this case. The stipulation also provides for a tracker related to the ARAM amortizations in order to make sure that they are ultimately no less nor no more than intended. The parties have included a provision related to valve and hydrant maintenance, calling for some discussions between primarily the staff and the company as to the best approach to account for non-labor costs related to those valve and hydrant maintenance activities. The parties have agreed to some annual reporting related to main breaks and water loss by districts. The parties have further agreed to some more in-depth analysis for any of the service areas that would have greater than 20% lost or unaccounted for water. In regard to the pensions and OPEBs, primarily that provision is an update from prior cases that just pulls forward the relevant dollar amounts and time periods for this case. There is an agreement that as to the next general rate case, Missouri American will include a class cost of service study that at a minimum includes the districts and classes that are approved in this case, as well as a separate class cost of service study for the sewer side. The company's depreciation rates will continue as they were ordered in the last case. Those are reflected at attachments D and E to the stipulation. In addition, there's an agreement that the Benton County, Woodland Manor, and Jackson Estates systems, which initially upon acquisition were on different rates, will be moved to the company's previously approved depreciation rates. As to lead service lines, the company will continue to replace customer-owned lead service lines. The deferred costs associated with those will be amortized over 10 years. Will earn carrying costs at the company's long-term debt rate and earn a long-term debt return on the unamortized balance in the revenue requirement calculation. Again, this treatment is consistent with what was approved by the commission in the company's last general rate case. Additionally, the parties have provided for treatment of Missouri American's deferred COVID-19 costs. Those deferred costs netted against savings through March 31st of 2021 are included in this case, and the company will amortize those costs over a 3-year period. The company has also agreed to adjust the way it calculates AFUDC on a going forward basis, and that calculation is included as an attachment as well in the stipulation. Generally, the company short-term debt followed by long-term debt to determine an AFUDC to apply to construction in progress. As I mentioned before, the rates developed in this case are going to maintain the existing tariff groups and districts. That is, for water, there will be the St. Louis County district and then the other Missouri district. On the sewer side, there will be the Arnold district and then essentially the other sewer customers. The rates that will result from this agreement are found at attachment G for water and attachment H for sewer. The low-income pilot program, by terms of the stipulation, would be continued with the inclusion of the loss in service area, which geographically makes some sense to that program. In addition to similar treatment to the existing, well, I want to say the existing treatment, but deferred amounts as of December 31st of 2020 are going to be amortized over 3 years, beginning with the effective date of new rates resulting from this case in regard to the low-income tariff program. And the company has agreed to meet with staff and OPC at a time period prior to the filing of the next case so that both the program and the data that's been collected can be discussed prior to the filing of that case. There's an agreement as to the amortization period for costs related to the Rogue Creek acquisition found in the stipulation. There is an agreement that the company will continue the inclining block pilot program in Mexico for residential customers. However, going forward, the spread between the blocks will be increased consistent with Missouri American's proposal in that regard. And lastly, there's a provision related to Sunnydale properties indicating that Sunnydale will be treated the same as rate J customers as long as rate J exists and Sunnydale meets those volumetric use requirements. The company believes that this stipulation and agreement represents a just and reasonable resolution of the rate case and requests the commission issue an order approving the stipulation and agreement and authorizing the company to file tariffs to implement the terms thereof. And with that, I guess we are available to answer any questions that you may have.
Thank you, Mr. Cooper. Are there commissioner questions for Mr. Cooper at this time, Mr. Chairman?
Thank you, Judge. I do have a question. So primarily at the beginning of this case, the company requested a revenue increase of about, call it 103 million. Is that correct?
I believe that's close, yes.
Okay, and a lot of the increase there that was requested had to do with requesting future test year items to be included. So my question is, what test year did you end up settling on in this agreement?
Yes, Chairman. I guess first I would say that there's a variety of things that are included in that original request, but ultimately, if you look at the ISRIS agreement, you'll see that the parties have agreed that ISRIS investments beginning January 1, 2021 are eligible for inclusion in the ISRIS. So I would tell you that we're working with plant that was in service as of the end of 2020.
Okay. Thank you, Judge. I have no further questions at this time.
Are there other commissioner questions for Mr. Cooper at this time?
This is Commissioner Reed. I do have a question.
Go ahead.
I know there were some, thank you, Judge. I know there were some changes, minor changes to the pilot program on the inclining block rates. Just general question, when is that pilot ending and when do you think you would have data to kind of report back on the results of that pilot?
So what is being considered in this case, Commissioner, is that at a minimum, Missouri American will meet with staff and OPC again prior to the filing of its next rate case to discuss data, results, and talk about what might be proposed in that next case. So at least sitting here today, it's contemplated that program would continue through Missouri American's next general rate case.
Any idea when that next general rate case is going to be?
No.
Thought that'd be the answer. Only other question I had for you, sir, is the revenue stabilization mechanism is not included in this. Is that correct?
That is correct. In fact, it's mentioned as one of the items in paragraph 22 that the company withdraws as a part of this stipulation.
So I know there was testimony that said that, you know, there's weatherization adjustment mechanisms, and I can't remember if it was your testimony or the staff testimony and said, well, then it's not really as much needed, but does the RSM take into account like conservation better than just the weatherization? And after that question, does the company continue to seek an RSM in the future?
Let me try to get at it this way, Commissioner. The statutory authorization for the commission to utilize a revenue stabilization mechanism for a water company is a little different than the authorization for the electric and natural gas companies. And I think it does permit the commission to take into account all things that may affect the the revenues collected by the company. So both weather and conservation, amongst other things as well. It's a fairly broad description. In answer to your second question, I don't think this should be taken as any sort of indication that the company doesn't continue to be interested in a revenue stabilization mechanism and ultimately believe that it likely has a place in the regulatory framework. But indeed, going back to where I started, as a part of the stipulation, in this case, the company has withdrawn its request for such.
Okay, I understand how negotiations and things go, but just wanted to just state that, you know, I believe there's still interest, at least from some people on the bench, that revenue stabilization mechanisms are something to continue to be looked at. Especially, I think they can take into consideration other things besides weather, and that is something that I hope companies and people continue to take into consideration in future cases. Thank you.
Thank you, Commissioner. Were there any additional Commissioner questions?
Not at this time, Judge. Thank you.
Thank you, Commissioner Holzman. I'm not hearing any other Commissioner questions for the company. Would staff like to add anything to the company's presentation?
Thank you, Judge. I think Mr. Cooper did a very good job of comprehensively explaining the stipulation. I would like to note that staff agrees that the results of this stipulation are just and reasonable, and we fully support its approval by the Commission. I'd also like to thank the various parties of this case. This case was presented under a very difficult situation. As evidenced here today, we're doing this virtually. In fact, the entire case essentially was conducted virtually, including staff's audit and all negotiations. And I think the parties worked diligently, and we've come to a good resolution. With that, I have with me today several members of staff, and I would be happy to attempt to answer any questions the Commission may have. And if I can't, I can direct them to the appropriate staff.
Thank you, Mr. Johnson. Are there any Commission questions for staff?
Mr. Commissioner Roop, I have one if the chairman does not at this time.
Go ahead.
Okay. So it kind of does follow up with the chairman's question to the company. So originally, your staff was advocating for a rate decrease, and now they're settling for a $30 million rate increase. So what has changed in staff's viewpoint, and is it mostly just the test year, or what information got staff off of its stance there should be a revenue decrease?
Well, I think ultimately staff was able to settle on a number just through the process of negotiation. However, with every case, as we move through from the update period into the test year, and we get some updated numbers, staff's position can change. While we did not reach the true up part of this case, staff was able to use information it had discovered from the company within the negotiation process. And then ultimately, negotiations are what they are. We do believe this is a very reasonable resolution.
So the process of negotiation is how you got to the comfortability with your staff's position, is what I'm hearing, with maybe some additional information that came to light from the company.
Yes.
Okay, thank you.
Thank you.
Any other Commission questions for staff?
Judge, I would add a little bit of clarification, if I could, to Mr. Johnson's answer. in his discussion about true up information, it's true, it's information that the staff discovered, but it's also true that by the time we got to the negotiations of the stipulation, we had gotten past that true up date, and we had gotten past the date when the company provided formally its true up information to the staff and all parties for that matter. So certainly there was, as the proceeding was designed, we were past a point when additional information was available and provided as a part of the process.
Yes, thank you, Mr. Cooper. I was referring, I believe, more towards the true-up testimony and hearing aspect, but yes, we were past the date by which the company shared true-up data with all the parties.
So you feel this is a more accurate reflection of the current situation?
Yes.
Thank you.
Thank you for that clarification. Are there any other commission questions for staff at this time? All right, not seeing anything. Public counsel, would you like to make any remarks?
Good afternoon, Judge. The luxury of going after other councils, I feel like most of the stipulation has been explained accurately. I would just add for the commissioners that, like, so the red meat and how to sell the stipulation is the company came in asking for 100 million. The stipulation claims they're getting a 30 million increase. That $30 million figure nearly equals exactly what the company would be collecting through their ISRIS charges, which is now being zeroed out going forward. So from public counsel's perspective, the company moved significantly towards a fair resolution of the disputed issues going forward. At this time, I'm available for questions. If I don't feel like I can competently answer a question, though, I may defer to an expert that we can try to drag down on the line at this time.
Thank you, Mr. Hall. Are there any commission questions for public counsel at this time? Mr. Chairman?
Thank you, Judge. Just to clarify, on public counsel's position, you did not sign off on the stipulation, but you were not opposing it. Is that right?
No, Chair Sylvie. We did sign on to the stipulation.
Oh, okay. I misunderstood. Thank you.
Are there any other commission questions for public counsel? Not seeing any. I'm just going to go ahead then. If the other parties would like to make statements, I'll just go down my list. Triumph Foods, did you have any additional input?
No, we do not. Thank you, Your Honor.
And Riverside?
No, Your Honor.
City of St. Joseph?
Thank you, Your Honor. Simply that the City of St. Joseph supports the stipulation.
The Public Water Supply District?
We also support the stipulation. Thank you, Judge.
Consumers Council?
Yes, Your Honor. Consumers Council also supports the stipulation. The overall rate change, the allocations between districts and between customer classes, as well as the other provisions were all taken into account. So we urge the commission to approve it.
Thank you. MECG?
Thank you, Your Honor. The only thing I'd like to add is kind of provide some clarity to the question from Commissioner Roop. One of the items that originally MECG supported a rate reduction. One of the items that would move the parties beyond that rate reduction up to the point they are now is we supported a 3-year amortization of the EADIT. Staff supported a 5-year at that time. As you'll notice from the stipulation, we have agreed to an amortization of 10 years. So what that does is move the revenue requirement of MECG and the revenue requirement of staff upwards. So Commissioner Roop, when you asked what changed, why are you going from a rate reduction to the revenue requirement provided in this stipulation, that is a big item worth millions of dollars So the movement from 3 years or 5 years to a 10-year amortization of EDIT provides for a lot of that difference that you were noting. Other than that, I would just support the stipulation.
Thank you, Mr. Woodsmall. Sunnydale?
Sunnydale has no additional comments, Your Honor, and we support the stipulation. Thank you.
Thank you. Are there any other commissioner questions for any of the parties, any of the other parties?
No questions, Judge.
Thank you. Right, I'm not seeing anything. Was there anything else from any of the parties that we didn't get on the record that you wanted to present to the commission? I'm not hearing anything. Well, I also appreciate that this rate case was handled entirely, pretty much entirely during the pandemic situation, and I appreciate the parties' hard work and cooperation in getting this resolved, and look forward to the next round. Is there anything further from any of the commissioners? All right. I think that will conclude this on the record presentation, and we can go off the record. Thank you all very much.